Okay, so I'm Antonio Glenn. I'm a local attorney here. I'm licensed in Texas and Maryland, DC, and some Virginia. And so I'm going to be talking to you all about trust today. We won't go a lot into the basics of the estate plan. We will cover it slightly, but I do want to focus on trust because many clients or potential clients come and they hear about trust or other estate planning documents or businesses, even LLCs, and they don't know exactly what it is. Maybe it's not defined to them properly, or the mechanics on how it's managed and everything. So the goal today is kind of go into that. So first of all, let me go in and say, hey, this is an educational course. This is not legal advice. I am an attorney, but I am not your attorney. So, but I am here to answer questions and give feedback when needed. So if you do have a question later on, please jump in and feel free to share. Please try to not make it too specific because we want to make sure that your confidentiality is intact and no one can kind of discover that. And attorney-client privilege does not apply when you have multiple parties on the line. So for that case, we're here for education and not legal advice. So yeah, just sit back and enjoy the ride. So first off, we're going to talk a little bit about wills and basic estate planning. And a will is basically a legal document that outlines for the testator or the person who wrote the will what they want to have happen at their time of death. And about 60%, maybe even 70% of people still don't have a will. I think a lot of people think a will and estate plan are only for the wealthy, and that's not true. So the purpose of estate planning is really to create a plan to distribute your assets uh, to your children, to your family, maybe charitable institutions that you want to donate to. The other purpose is to avoid probate, which can be very timely and inefficient, and it can also be expensive. In addition to probate, probate is not private. Probate is a very public matter, and we'll get into that when we start talking about probating the will and those things. But a part of your estate planning includes this. And even if you have a will, as you'll see, you'll still go through probate. So a little bit of what we'll be discussing is probate minimization, or to limit probate significantly to keep your costs and time down in the courtroom. The other thing is providing financial security and long-term care for individuals, especially those with disabilities. So today we will cover supplemental needs trusts. I think a lot of people think individuals with disabilities are kids with disabilities, but this can also mean to the older population that we're getting, the boomers. Now kids are going to start having to look after their parents, and their parents will want to get Medicaid or long-term care or some other Medicaid or governmental benefits. And so some supplemental needs trusts may be used for them. And then lastly, we'll talk about some asset protection on how to use a trust for asset protection. And we'll go through some of that information as well. So a will, again, the core components of the will are the testator's intent. So the person who sets up the will or drafts it is the testator. It's your last will and testimony. You're giving your intent. My job as the attorney is to take what you say and draft it so when someone reads it, they can execute it. The executor, they can deliver on what your instructions were. And that's what my job is. The will also names guardianship provisions for minor children. And this is very important. Sometimes we include it in the trust, or sometimes we include it in both. I would definitely have it in the will. And for many clients here, I do a separate guardianship provision paperwork so they don't even have to go to probate. They can just have the guardianship documents ready. You can also have limited guardianship. So say, for instance, you, a husband and wife, are traveling abroad or somewhere, maybe for a couple of months at a time. You can do a limited guardianship for your kids, and you can, whomever that guardian is, can maybe put them in school, have money and access to take care of them, and other things. And then there's asset distribution with your will. Most of the time in the will, you'll put in, hey, I'm going to get my car, or I want to give this jewelry to my kids. And so you'll specify those things. But again, it's much easier to do this with a trust, and we'll get into that as well. One requirement about a will that the trust does not need is that a will requires witnesses and a trust does not. A trust can be notarized, which makes it a little bit more valid. It's not even required to be notarized, but a will definitely needs to have two witnesses. And I've seen people submit documents and say, "Hey, this is my will," and the document has been notarized, but it doesn't have the witnesses, so it won't meet the prove up standard in court, and now you have a dilemma on your hands. So that's why do-it-yourself estate planning isn't always the best policy. Some additional documents in a basic estate plan is a durable power of attorney. A durable power of attorney basically authorizes, in many cases, the husband or the wife uh, control and managing financial affairs for that individual. So husband and wife give each other this durable power of attorney. Let's say husband is the primary breadwinner and caretaker of the home. Something happens to him, he's ill, and he can't go to his place of business and shop or go to the bank. The wife has this POA that she can go to the bank, and maybe even have a business POA. She can go to the business and handle affairs on her husband's behalf, and be able to take money and manage the affairs of the household with this durable power of attorney. You also have a healthcare power of attorney, which almost is kind of the same thing, but it's for making healthcare decisions for that individual. Some husband and wives don't share that responsibility. I know some couples are like, no, I want my mom to be my healthcare power of attorney, or I want my dad because he's more calm and he's a doctor and everything. And sometimes they do it that way. So that can be a part of it as well. And then you have the Advanced Healthcare Directive, which allows the person to, understand and know what your last wishes will be, and for them to sit in on that and make those decisions with you. One thing about all of these is these additional documents, once the person who drafts these is deceased or passes away, these documents are no longer valid. So they no longer take place. So I have people call and say, hey, my spouse passed away. I need to get a POA so I can manage his affairs. You're not going to use a power of attorney in that situation because it's not going to be valid. And any powers that you had along with it have now been extinguished because that person has passed away. And that's why we need the estate planning and the other documents in place to ensure the continuity in affairs when that person does pass away. The big reason, again, to have basic estate planning and more sophisticated estate planning with the trust is to avoid probate. Again, we talked about it's open to the public. I've had clients come to me with the wills that had their social security number in them, and I had to redact them because this is a public document. Once the judge in the court gets it, it publishes it because people need to come. Creditors come forward, and other heirs may see it and come forward and say, "Hey, that's my family member. I need to come forth and get whatever distribution was supposed to be given to me." It can be very time consuming because by the time you have to hire an attorney, you have to file the documents with the court, you have to wait for a court date. If you need witnesses to come, their availability, and then the cost continually rises with fees or attorney fees or other expenses that you're trying to avoid. So we'll show an example shortly what those costs could look like. And then the expenses paid, distributions may not be as you intended as the as the testator. So you'll want to have those under control. And then you don't have any control, right? The decedent has no control when they go to probate. You kind of now leave it into the judge's hand or whatever attorney is managing it. and that's not always the case that you want to be in. So here's an example of a real estate deal, or I'm sorry, of a couple, Han Solo and Princess Leia, for all the Star Wars fans out there. And you can see they basically have what we have. They have their house, which is 400,000, a bank account with a good amount of savings. They do have some anticipated inheritance or money coming from them, maybe another house. I know many couples who, hey, once I pass away, my parents are gonna give me their home, and they have life insurance out for themselves, and their parents have life insurance out that'll come to them. So in this example, you can see that, oops, I'm sorry. You can see that this is their value. This is the value of their estate. So at the end of the day, there's something called a federal exemption. I really won't get into that because it complicates matters, but let's just say the federal exemption is 13 million. That means you can gift away 13 million without any tax ramifications, right? But in this scenario, what you have is you have someone getting uh, if you had a probate of this amount in Texas, you're looking at about $180,000 in probate fees. Most people think, oh, I don't have this much, right? I'm far off. Even if you cut this number in half to 3 million, right? Then your estate, for that matter, will probably still be about $90,000 in Texas for estate matters, because your house and all these other things that make up your estate. We don't think that is, we just, oh, those are things. No, when it comes to taxes and everything, it's all put together in your estate and as a part of your estate plan. And that's what I look at to see, hey, we could save you a lot of money if we do this estate planning, because this is what you're looking at in probate fees alone. And we haven't even talked about other taxes if you don't do the estate planning properly. Okay, so what we're going to talk about next is the meat and potatoes of it, is our trust, and why trusts are in the mainstream, why trusts are beneficial in your lifetime and once you pass away. Dynasty trust and things like that have been around for a really long time. This is how you see, the Kennedy family or Rockefellers, and they're always saying, "What? Oh, you're a trust fund baby." Yes, because someone properly set up a trust for them to last long, with instructions for distributions where they can control and maintain income in that trust. And so a trust is really just an agreement held between the third party and the trustee that holds the assets for the beneficiary. And so we'll get into what that looks like for trust. So we have a variety of different trusts. You have special needs trust for people with special needs or who needs getting Medicaid, or maybe they're getting Social Security benefits. So we would have a trust for them because we don't want them to have to spend down their money in order to get the governmental benefits, or they could lose their governmental benefits. And we'll talk about that later. You also have business trust. And a business trust is what some businesses use to handle affairs. Maybe an LLC may not be the best thing for them. You have a rental property that you can't roll over into a limited liability company because the bank is going to accelerate your loan. And so instead of having a 3% mortgage rate on that rental property, if you transfer the title of that property to a LLC, the bank is going to say, "Hey, look, not only do we want 5 or 6 thousand in closing costs, we also want to take your interest rate from 3% to 6%, and now you've defeated the whole purpose of putting this property into the LLC. But maybe a business trust might be able to be used for you." We're going to also talk about domestic asset protection trust. So a domestic asset trust is a shield against creditors, and it's really designed to help people keep their assets intact, but also offload them into a trust. And we'll get into that specific trust today. You have a testamentary trust, which is included in the will. And I do this for single parents who don't have the time, or maybe they don't have a lot of assets to manage a trust right now. But what they want to do is they have minor children, and they want to have some structured way for their minor kids to get their inheritance. instead of a child getting, let's say, a $500,000 life insurance policy when they turn 18 because they don't have a trust set up, and as an 18-year-old with $500,000, basically you may not manage that money the way your parent would see fit for you, right? So let's stagger the payments out. Let's break it out. And a testamentary trust can help you do that without having to manage the trust within your lifetime and handle in all the maintenance. You have a spendthrift trust for a beneficiary who has a lot of creditor issues. Maybe they owe a lot of money, or they're in debt, or they have some substance abuse issues, and you don't want them to have access to the funds the way they normally would. We set up a spendthrift trust. And then you have your generation skipping trust, which is a trust designed really for your grandkids. And then you have a life insurance trust, which is to hold life insurance policies to pay taxes. This is something that the wealthy do, where instead of using money or cash from the assets that they have, they buy life insurance to pay the taxes and they just put it in this trust so it's not a part of their estate. So um, those are the variety of trusts, right? But trusts are basically broken down into two departments: revocable and irrevocable. So although I just showed you seven. There are many, many more trusts that you could set up: slats, grats, crummy trusts, other kind of, land trusts. There are so many more different kind of trusts that I could show you. But basically, the trust will be coming down to two different kinds of trust. And this is what will make it easier for you because you'll tell the person, hey, I need a revocable trust or irrevocable trust. Most of my clients are going to want a revocable trust because, like the word says, you can revoke it. You can put assets in the trust and you can take assets out the trust. You have a lot of flexibility with it, right? And that's what you can do. So, here are some of the key differences between the two trusts that'll be good. So, a revocable trust, the grantor is the person who sets up the trust, who puts the money in. And then an irrevocable trust is the trustee who owns control of it. Now, in a revocable trust, you'll see that person can be the same person, but in an irrevocable trust, they cannot. And we'll go into a little bit that later. Flexibility. You can modify the trust very easily. With an irrevocable trust, you can't because someone has to sign off on it, namely the trustee and sometimes the beneficiary. Tax liability. The grantor, the person who set up the trust, is responsible for the taxes. And then for an irrevocable one, the trust is responsible for the taxes. And you'll see that later in the slides. Included in your estate. So back in the example that I showed you, if you have a revocable trust, that number that goes to probate or is a part of your estate, even though it's in the trust, it's still going to show up in your estate, and you still may or may not have to pay taxes for that. And an irrevocable trust, this is what the wealthy do to move the taxes off their balance sheet onto the trust balance sheet or to the beneficiaries. Maybe someone of their kids isn't working, so they may be in a very, very low tax bracket and they can take the income from the trust, where the person who sets it up may be very wealthy and that tax hit could be very, very inefficient for them. And then we'll talk about asset protection. There's not a lot of asset protection for a revocable trust, as you'll see later, but the irrevocable trust does have that, and that's another benefit. So here are some of the pros and cons of them. So you have the revocable trust, which again helps avoid probate. It protects your wishes and allows you to say, these are my instructions. Maybe I want my child to go to college. Maybe when they turn 25, they can buy a car or use some of the principal to buy a car. And then it's modifiable. You can say, hey, you know what? This heir has matured out. Now I have a younger child. I'm going to move more of the bulk of the principal for that younger child. And you can make different provisions and instructions in for them. And so that's what you'll do. And then the irrevocable trust, it provides protection for lawsuits. Your trust does have that protection for you because it's not a part of your estate because you don't have control of it. Again, it reduces the estate tax. And we'll go a little bit into the different taxes. That'll be a different webinar coming up soon on what the different taxes are: estate tax, gift tax, inheritance tax. People hear these terms, but they really don't know what they are and can't distinguish between them and how they apply to them. So I will have a class to discuss those and how it works with a lot of people. And then you also have this grant access to programs and everything, and go from there for medical benefits. Okay, so we do have a question. Can the trustor control the trust until he is incapacitated or dies? And the answer to that is yes. And so while we're on this slide, I'm glad I looked. For a revocable trust, the grantor, and let me see which slide. Let me go to the slide. Okay, I took it. So in a revocable trust, you have three key features. You have the grantor, the person who sets up the trust. You have the trustee, the person who manages the trust here. So you have the grantee, the trustee, and then the beneficiary. In a revocable trust, that person is going to be the same. So you, as the person who sets it up, is like, hey, I'm in control of this. Most of the trusts that I set up for revocable trust, the husband and wife are co-trustees. They manage the trust on their own behalf, and they're the beneficiary. Their kids are the contingent beneficiary. So that means if something happens to the both of them, then their kids step into their shoes and become the main beneficiaries. But then that you have to think about it on levels, and I think I'll do a breakdown. So to answer your question, yes, the co-trustees manage the trust. If one trustee becomes incapacitated, as you say, the other co-trustee is there to manage it, whatever's in the trust. And this is why funding the trust is so important, because the trust needs to own the assets that you want the trustee to control. And that's a big piece of it. And we'll go over those slides shortly. So again, here's a quick slide on, a revocable trust being, it can be amended, it can be revoked during your lifetime. It's a lot of flexibility. The purpose of a revocable trust: avoidance of probate. Number two, another big key point with a revocable trust is privacy. It's a private document, unlike a will that goes to the probate court and then gets published in a publication for everyone to see. Your trust is a private document. And I encourage my clients to not name their trust with their name. That offers even more privacy because they just can't look up, oh, Antonio Glenn, revocable trust. Okay, well, he has a trust. Let's try to find and see what assets are in there. So my trust would be something like, law and trust account, trust, where someone's like, who owns that and who's it connected to? And so now you have, this chain of anonymity along with it. So with the trust, the estate management upon a death or incapacity, to answer your question, Mr. Hyder, then the privacy, and then you got the distribution schedule. So whether you have a blended family, grandkids, maybe you want to give to spouse a certain portion, and then you want to give to charity, you can put all of that in the trust. And not only does it maintain in your lifetime if you become incapacitated, but when you pass away as well. The other bigger piece with having a trust set up, again, is supporting your minor dependents. So in the trust provisions, many trusts have what we call HEMS, health, education, maintenance, and support. And the funds are there to support that individual, that beneficiary. And namely, you're the beneficiary in the beginning, right? So say something happens to you, you have these trust funds that you can use because you're the beneficiary until you pass away. And so the trustee, which would be you as well, can say, hey, I want to manage these up until a certain age. You can also get a corporate trustee. I have a lot of clients who say, hey, I want maybe it's for my niece and nephew, maybe it's for a blended family, and you have a corporate trustee help handle those matters for them. So it's off of your plate and onto theirs. And in some cases, when you have a court appointed guardianship, you're required to have a third party trustee to keep everything transparent. Um, so again, this is what a trust, which you have. Maybe again, here in this situation, you have that trust set up to provide guardianship. Let's say for a child who's now been orphaned, they have a trust, but now they have a corporate trustee managing their funds, which helps benefit them from any kind of corruption or theft or things of that nature. Another key piece for revocable trust that a lot of people don't think about is out of state property or out of state probate. I have many clients who either they live in Dallas or even in the DC area, they buy a vacation home. I bought a vacation home in Florida, or they bought a vacation home in Hawaii, right? Maybe that timeshare or something like that that they've invested in is not in their home state. And so if they don't have an estate plan set up properly, not only would they have to remember that 180,000 that I showed you, you might have to pay in probate expenses or 90,000 or 20,000, whatever it may be. Now you have to double that because now you have to go to wherever this property state is. You don't know their laws, you don't know their courts and procedures. You're more than likely going to have to get legal counsel, more than likely going to have to take multiple trips there. And if the will isn't done properly, now you have an ongoing issue to try to resolve something that could have been handled on the estate planning side very quickly and easily, and it could have helped us prevent this secondary probate. And this is for real estate vehicles, different assets. And it just would cut down on your administrative costs because not only do you not have to wait for a court date, it's done. So that trust, that other trustee or the beneficiaries can jump in and manage those assets because they're owned by the trust. The trust owns them. The individual doesn't own them anymore. And whomever is trustee can manage these assets a lot easier. So the tax implications with revocable trust. We won't go a lot into the tax, but again, I wanted to share this that the grantor, the person who sets up the trust, is liable for the trust income. All trusts don't have income. Sometimes they do, sometimes they don't. But if they do, then your CPA or whomever, even myself, you call, hey, I need to report the income from the trust on my 1040, which is pretty simple. Then you have your estate taxes. So just so you know, in estate taxes, whatever you have in your estate, if you have more than $13 million, you would pay tax on that. Many people and many clients don't have more than 13,000. And as a couple, don't have more than 26. I mean, I'm sorry, I said 13,000. Don't have more than 26 million. So 13 million or 26 million in order to pay taxes. So for most Americans, estate taxes are not the biggest of an issue for them. If it is, yes, we're going to do a lot more tax planning and estate planning for you to help you avoid estate tax. Now, you do, again, have probate tax and some inheritance tax in certain states. And that's what we want to try to avoid, the gift tax too. So a gift tax is I can gift to, let's say, my wife anything, and there's no tax consequences. I can give to my wife the entire world, and the IRS will say, "Hey, they're married. That's a gift to his wife. They're bonded." Now, if I gift it to my daughter or to my friend or to an institution, I can only give up to 16,000. Anything above that 16,000, I would have to pay taxes on. But you have what's called an exemption that stops you from having to pay taxes on it. And that'll be in my next call on taxes is the federal exemption tax limit. Another big key piece about having a revocable trust as well is what's called a step up in basis. And a step up in basis basically means that uh, if I purchase a home, let's say Mom and pop bought a house in Dallas in 2000 for 200,000. And now that home has grown in value because so many people have come here from California. And now that house is worth 600,000. You have about $40,000, I mean $400,000 in appreciation. And actually, I put in an example to go. So the step up in basis is basically the step up in value that you get from the home if you once you pass the property along to your kids, or if you put it in a revocable trust. So again, starting my scenario over, married couple, husband and wife, placed the value property at 500,000 with 200,000 basis. So the 200,000 basis is how much they paid for the home in 2000. The home now is valued at 500,000, of course, because the what is it, Collin County and Dallas County board come in with the appraisal and they keep bumping up your your taxes for your home, right? So now your home is valued at 500,000, and now you fund it, transfer it to the trust. So upon the first spouse's death, the property market value is 600,000 now. So it's gone up another 100,000. So the decedent's portion, whomever passed away, 50% of the home is somewhat split to them. So now that new basis for his portion is 300,000, and the other spouses their basis would still be at that 100,000, which is half of this 200,000. So upon the surviving spouse or the second spouse's death, the entire property receives another step up in basis, now to the 700,000 level. So what this does for your beneficiaries is, instead of, so this 200,000 is now 700,000. That's a difference of $500,000. Guess what? They don't have to pay capital gains on that because they got the step up in basis. And that's what you really are looking for. And sometimes if you put a property in an irrevocable trust, you don't get that step up in basis, but you do get it out of your estate for estate planning purposes. So I don't expect you to remember all of this, but I did want to share step up in basis so you understand and you can start thinking about that term when you're thinking about doing your estate plan and moving forward in that situation. So now we'll get into irrevocable trust, the opposite of the revocable trust. Basically, it's almost the same thing, a legal arrangement with the grantor, transfer assets into the trust, which is what we call funding the trust, but they relinquish control and ownership. And then they make the terms unchangeable without the beneficiary's consent. So now the beneficiaries have to agree to make changes, which is you give up that control. I have clients who do this, but the kids are understand there are more assets available. So they're not going to interfere with their parents' plan to unload these for whatever purposes it is. You also have irrevocable trust for other matters, right? Say, for instance, you have uh, maybe you have kids, minor kids, who parents have passed away, and now they have some other family member or someone else managing their funds. Maybe there was some life insurance and stuff left for them. You would use a irrevocable minors trust for them that can be modified outside of a trust protector. And that's what I play is I set it up and then I'm trust protector because I can look at the trust and make modifications to it, but I don't have any control over it, and that's what I do. And so that's what you try to do in those situations. So most of the time, an irrevocable trust can be modified or revoked once it's established. Um, you have this control. The control is given to the trustee, and then the beneficiary has some say in the situation. The structure is rigid, but the tax and asset protection are really there and affordable to anyone who wants to set up the irrevocable trust. You just need to know going in, this is what I'm setting it up for, this is the purpose of it, and this is what I need to use it for. And again, you can have multiple trusts. Maybe you have a family revocable trust with your spouse, And then maybe you have an irrevocable trust for some different type of assets that you want to put in there that you don't mind relinquishing control of. So the tax implications for irrevocable trusts are the trust itself is responsible for the tax on the income. Let's say you have, 5 rental properties, maybe a really nice brokerage account with Bitcoin. You're going to have some income, or the trust is going to have some income, and the trust would file its own return. The irrevocable trust also would get its own EIN number, tax identification number. It wouldn't use the grantor's social security number. So that's another difference. And then your estate taxes are not included. Whatever's in that trust is not included in that trust, and go from there. So that's what we have set up for that. Um, Nice. So, oh, let me go back really quick and say one thing before we get to funding the trust. If you have a revocable trust and you pass away, that trust then becomes irrevocable because the grantor who set up the trust is no longer living, so they can no longer modify or amend the trust. So then it becomes irrevocable, and then it gets its own EIN number. It doesn't necessarily mean that the trust expires either, because the trust can still be active. It can still have income and other things in it, and set up for those individual beneficiaries or continued beneficiaries who are now beneficiaries to take from the trust. So maybe kids, grandkids, or whomever. So the trust can still be active, but now it's become irrevocable because the grantor has passed away. So one key piece about trust is funding the trust is one of the most important components. And I often tell my clients, come back to me, bring your paperwork. Let's sit down, let's fund your trust, let's pull everything. So funding the trust is really transferring ownership of property from your individual name into the name of the trust, or in care of the trustee, the person who's managing the trust. And so, for instance, ownership transfer, assets must be retitled in the trust name, be included. So let's use the brokerage account. Brokerage account is in my name, Antonio Glenn. But hey, I want this brokerage account to go to the trust. So now AMG, financial trust, I'm going to retitle that brokerage account over to that trust, or I'm going to retitle my home over into the trust. I'm going to retitle my car over into the trust. So you're going to retitle certain assets to the trust. You're not going to retire an individual retirement account into a trust because it's an individual retirement account, and you can't do that with that. An individual retirement account needs to be with a person and a social security number. So how are you going to get the funds from that IRA or life insurance policy into the trust? And that's when we get your beneficiary designations. So we call the bank or we call the insurance company and we say, hey, we need the beneficiary form. Most couples say, hey, I put my spouse as 100% beneficiary on that form. And we don't want to do that, right? Or maybe we do, maybe we don't. But in most cases, if you want the trust and the trustee to manage those funds, you want it to run through the trust. And doing the beneficiary designation, naming the trustee as the beneficiary is what's going to help you resolve that. And those are the two key ways of what we call funding the trust, or getting assets into the trust. You can technically do personal property. Maybe jewelry, you can do it. Let's say you buy a diamond and it has the serial number and certificate. Hey, I want to retitle that from my name to the trust, right? I want to retitle this home. So retitling a home, now it's in the trust. The trustee manages it. So now the kids can't fight over it because hey, the trust owns it and it's making, money as a rental property. Now that money flows through the trust and then flows back out to the beneficiaries as income. And that's what you use it for. So if one person doesn't have to do it, you can have multiple trustees. You can have 3 trustees, 4 trustees. Many trusts were set up, again, like I said, by the robber barons because they were really useful tools for us to use because we didn't always have options like limited liability companies and all these things are new statutory things that you can use for business that weren't around before. All right, so why fund a trust? One, you want to safeguard your property for future generations. You have the control mechanism that sets in once the trust receives the property. Again, you avoid the probate because now the trustee manages whatever in the trust, as opposed to in the will, they're having to go to probate, get a letter of administration, or get some heirship documents and everything. And it can also reduce estate taxes. So here, here's just a slide. I hope you guys can see this a little bit. But basically, the grantor, the person who sets up the trust, he or she is gonna execute the trust agreement, right? And then that trust agreement is gonna identify the beneficiaries, and it's gonna set the rules on what the beneficiaries have to do to receive their fair share of the you're going to appoint the trustees, and then you're going to fund the trust with cash, land, stocks, bonds, businesses, whatever you may choose. So real estate, we transfer that by deed. So if someone wants to transfer a property into the trust, send me the deed and I'll retitle it. For banks, we retitle those in those accounts. And again, life insurance and some of the other assets, we change the beneficiary form. So there are different ways of funding the trust. You got to know which one does what. But it's key and vital to do that in order to move forward with setting the trust up properly. Here's a little process where we won't go a lot into. It's a little bit more technical, but basically, when I send out the recording, this shows the spouses establish the trust. They give it a name. They act as co-trustees. When the first spouse passes away, what does that look like for you? Now you have a survivor's trust, which you don't set up, but it's set up within the trust. And then you have the decedent's trust. So I pass away, the stuff that I owned and I have control over it, that's what's going to happen. Stuff that my spouse has, she'll manage and give away when she passes away. The survivor's trust is able to manage their own. And then when the surviving spouse passes away, both the survivor's trust, the spouse who lived, and the first who died, now they both become irrevocable, and now it all goes to the kids or grandkids or whomever down the line. So that this slide will be in there for all to review and go from there on. Just the flow of a trust kind of administration on the back end. Um, and if we have time, I'm more than happy to pull up a sample trust to show people. It's about 80 pages, so I didn't bring it in because we're already a little bit behind. But I want to get into the two main trusts that I wanted to talk about this evening, which a lot of clients come to me and say, hey, I want a trust. Someone told me to set up a trust for asset protection. No, they did not. Or if they did, maybe you misunderstood because, again, as we talked about earlier, a revocable trust isn't always the best option, but you do have some in some states. Unfortunately, one of those states is not Texas. And so the domestic asset protection trust is one that's set up. It is somewhat irrevocable, but it allows you to have creditor protection. In these DAPT states, you do still have flexibility to make changes, but also have the creditor protection. And that's what you want. That's what the revocable trust doesn't is modifiable, but it doesn't give you the protection. With the domestic asset protection trust, you get a little bit of both, and that's why it's very attractive to people in those situations. So here you have 17 states that have. And so most of the states, one state I'll be barred in soon is Virginia. Another state close to us is Oklahoma. But what you'll hear people on TikTok or YouTube say, set up a Delaware trust or set up a Nevada trust or a Nevada holding company or something like that. This is what they're referring to. They want you to set up one of these domestic asset protection trusts in their state, and then you get this asset protection. But there's a gap there, and that's what we're going to talk about what that gap is. A domestic asset protection trust is a great idea if you live in one of those states. But there are other things we can do to set up asset protection for you. And everyone doesn't really need asset protection. I know they think they do, but if you don't have a lot of tangible assets, especially like Texas, where we have very, very strict homestead laws, and limited liability companies have also a lot of asset protection that comes along with them, you may not really need this asset protection trust. So a domestic asset protection trust, one, it needs to be set up in the US. It does have a very strong spendthrift clause that prevents creditors from accessing the funds in it. And the distributions are discretionary. And so discretionary distribution allows you to say, I'm not going to take a distribution from the trust. If I need money from the trust, guess what? I'll be an employee of the trust, and I would take a check from the trust in order to pay me to get money out of the trust. So my creditors just won't be lingering, waiting for me to have to take a mandatory distribution at the end of the year. Because on some operating agreements or trust documents say, must provide a certain amount of income annually, and you may not always want that. And then it's self-settled, where assets contributed by the beneficiary with the creditor protection in those states, and that's what it's set up for. So those are some of the key provisions. But again, now we have a domestic asset protection trust, let's say in Nevada or Oklahoma, a neighboring state to Texas, and then you have a non-DAPT state as Texas, right? So crossing the state lines, if I have assets in Texas, but now have an Oklahoma trust, what's going to happen with that, right? The courts may not rule in my favor and give me that asset protection because my assets are in Texas and the trust is set up in Delaware. And you can set up a trust and you can change what's called the situs. You can change the law that the trust is managed under. So you can do it. You can say, hey, I'm setting this trust up and I want it to abide by Delaware law, Nevada law, Oklahoma law. But you still have all your property in Texas, and this law doesn't really favor that. So it may not be a useful tool for you, where LLC would probably be a better tool. And so risk, as a Texas resident in Nevada, it may not protect your assets, so it's up at risk. But an asset protection trust is available for some individuals, but what we kind of recommend for people to do is set up an insurance policy for asset protection. Set up business entities like a limited liability company or corporation, because those are guaranteed to offer limited liability protection. And guess what? Your trust can own that limited liability company, and no one knows who owns the trust, right? Because it's a private document. So when they go to the Secretary of State for Texas's website, they look, oh, I need to, sue, I need to sue Texas Rental Property LLC. Number one, what they have to do is they have to get what's called a charging order. And a charging order is the only way that a creditor can reach in, can reach into the owner's pocket to get money out that's owed to them. And that's very difficult to do because the owner has to take a owner distribution or owner's draw in order to get that money. That's where that spendthrift clause comes in. And that's also where in the limited liability company, it's discretionary. I don't have to take a draw. It's discretionary as a member. But guess what I can do? I can work for the LLC and get paid a paycheck and avoid some of those costs. So you have some different type of alternative asset protection strategies, including insurance policy and these other business entities, which I refer my clients to help them set it up. Also, you're able to take a lot more expenses, operating expenses with these entities that you don't have all the flexibility with a revocable trust. So in conclusion on that, my first rule of thumb, and this is for educational purposes, this isn't for a legal thing, is just don't do it yourself for asset protection. It's best to consult with someone. It doesn't have to be me, but maybe if you want to roadmap with me, of course, at the end, I'll give a link to set up a meeting with me, but you can get into a lot of pitfalls if it's not set up properly or if it's set up in a state and you don't connect it to Texas in some way. I've seen that happen a lot where there are a lot of gaps and people think they're protected, but they're really exposed. And then they can't manage the out of state asset in the early zone. So next, we're going to go into supplemental needs trust, and we'll pick it up because we have about 11 minutes. So supplemental needs trusts are basically really set up for people who have disabilities. They can be young people who were born with disabilities. They can be people who have been in an accident and now they've become disabled, or maybe you have an older population, which we talked about earlier. Now they have disabilities as they're getting older, maybe dementia or Alzheimer's, and they need long-term care. They need Medicaid, nursing homes and nursing aides and ADA accommodations for an aging parent can be very expensive. And so a supplemental needs trust can really do a lot to help them. So it's also known as a special needs trust, and it's really designed to help. In order to get government benefits, you are not so really supposed to have more than about $2,000 in cash and maybe a home. That's about it. If you have more than that, the government, in order to give you Medicaid, it's a 5-year window. You'll come into the office. I need to apply for Medicaid. They'll want to see what you have, assets and stuff for the past 5 years, and then say, hey, you got, retirement, 200,000, you got another 100,000 in this brokerage account, you have all this money everywhere. Either you're going to spend that down or you're not going to qualify for Medicaid. And even though that money sounds like a lot, 500,000, you've worked so hard for that, right? You don't want to have to spend it down really fast on a nursing home or nursing aid or other accommodations in order just to get Medicaid. You would at least like to have some of that money to live off of, to keep a quality standard of living for yourself. And maybe, yes, give some away to your kids because you work so hard for it. And you've also paid into Medicaid and Social Security as well. So you'll want to have some of those benefits support you. And this is what's called Medicaid planning. But sometimes what you need is this supplemental needs trust to park assets into for future generations, but for your livelihood as well. So you have a first party special needs trust, which is funded by assets belonging to the beneficiary, which is you. So let's say we have a client got hit in a hit and run accident, won a big lawsuit, but now they're in a wheelchair. It would kind of be unfair that they have to spend down their $500,000 lawsuit winning just to get Medicaid because they got into an accident, right? So you don't want that. So with the court would say, hey, okay, we'll set up a supplemental needs trust that's discretionary and it's supplemental. It's not supposed to supplant, right? So I get my SSI, I live off that, I live off Medicaid, but this other money from the lawsuit, it helps me enhance the quality of my life. I can get a better wheelchair. I can get respite care. I can go on trips with people and get a break from my nursing home or whatever because I do have some funds available. And then that's where the third party comes in because maybe you have a supplemental needs trust that your family funds. So I have siblings with special needs, right? So in my life insurance policy, if I name them as a beneficiary and they got $50,000, guess what? Their Medicaid and Social Security benefits would stop as soon as they get a check from the insurance company. And that kind of defeats the purpose of gifting it to them because now they got to spend it down as opposed to hold on to it and let it supplement their life. So then if I'm gone, my sisters can say, hey, our brother left 50,000 for you. Now we can use this money to send you to a camp for the summer to get respite care, which gives the individuals a break for someone with disability. You also have pool trust, which a nonprofit organization runs and manages on their behalf, and they can do that as well. And there are a bunch of seminars and things that go through this, but many trusts that I set up for my clients, you'll see an S&T provision in the trust. And many trusts that I provide for clients, they have basically contingency clauses. If this happens or if that happens, things that we can't predict. I can't predict if a client may quote unquote gift money to one of their kids that now hasn't had an accident and they need a supplemental needs trust. Where if that trust were to trigger and give $100,000 to that beneficiary, now you have a you have a problem and you have to work through it and spend a lot of money to try to repair something that shouldn't have been that way. So we have these contingency clauses in our trust to make sure they help people in those situations. So as you can see, the benefits of the supplemental needs trust: assets don't count toward the beneficiary's personal resources limit, which is that $2,000 for Social Security and Medicaid. They're managed by a trustee. I know corporate trustees who help manage special needs trusts for individuals. The ongoing benefits, basic living expenses, again, improve quality of life, maybe buying a new bed or some type of trip, or going to other events and things. And they cover non-essential expenses, as you can see here. So, like my brother, join a gym membership, right? You want to go to the gym, exercise, keep them active, keep them out the house, excuse me, going on activities. That's what those funds can do. And so that's what a supplemental needs trust is for. So this is when we would use the supplemental needs trust. Again, if a client comes and says, we're not getting any governmental benefits, then I don't need to push you into getting a supplemental needs trust because you're not at risk of losing anything. Now, if you think you may want to go after supplement SSI, which is Social Security benefits or Medicaid, then yeah, I'm gonna say, hey, maybe we set it up now, and all the assets you start pushing into that S&T trust. So if you do get Medicaid and it's a 5-year look back window, you're kind of free and clear. Again, we talked about personal injury settlements would go into here. Inheritance, like in my situation, to give to my siblings in an inheritance situation, I would want to set, and I have set up an S&T trust for them so they can get money from other individuals as well. And then it's there for long-term planning for their beneficiaries and everything. So here's a slide for managing the supplemental needs trust. If nobody really goes through it, you can see it in the video when I share it. But really, is the trustee's duty is to manage the assets in the trust. They have these allowable expenses that they need to follow and go, and it is strict on what they can do with the payments. So there's no looking back on that or fraudulent transactions. Um, Here are a few pitfalls on supplemental needs trusts. Again, uh, it can get disqualified if it's funded improperly, if you're not monitoring the laws in the S&T trust in your state, or something like that. And then trustee mismanagement can be a big thing. So sometimes having a corporate manager, corporate trustee manage the assets is really good. And then you have Medicaid payback. So if there's if you have a first party supplemental needs trust, what happens is Medicaid says, hey, we've been paying for your expenses. You have all this money left over in your trust. We want to get some of that back. We want to recoup and get you to pay that back. And if that's not what your intentions are, then you would definitely want to set up a third party supplemental needs trust. And that's something that the client needs to know, because if they don't know, now you're jeopardizing money that you thought can go maybe to another child with disability or something like that. And then you also have an ABLE account. And anyone who has supplemental needs trust questions, I can discuss ABLE accounts and these other types of trust with you one-on-one. So in conclusion, again, we want to ensure that we spoke with a professional about this. We reviewed the estate plan, as these are not do-it-yourself trusts. I know some people always say, hey, I can do a will, or I can do my estate plan on my own. I can go to LegalZoom, or I can go to ChatGPT. I don't think that's going to work. So one story that I had a client come, the niece came, uncle passed away. Uncle had a second family that no one knew about, and he thought he had a properly executed will. He did not. He didn't have any witnesses. So now there's already a lot of family turmoil. So now they have to come together to try to figure out what are they going to do with their, deceased uncle's estate. And so it can cause a lot of problems if you aren't set up properly and there are unknown circumstances that are out. there, it can cause for a lot of headache in that situation. All right. So why work with an advisor? Again, you can see some of the pitfalls for some of these other sophisticated trusts that are set up. That's why we're here to offer feedback. We're here to guide you at AMG Council. I don't do a hard sale. So I won't forward the slides, but I am going to send out this recording. That's why I did the replay, because the first replay on Saturday didn't come through and some people couldn't attend. And so I will send it out, but I will send out a primer. And what the primer is going to be is a 1 or 2 page synopsis of the things that I've discussed. But I'm fearful to send out um, this full slide deck for liability purposes. But if you do have questions, but I will send out a primer with some information about, revocable trust, irrevocable trust, other kinds of trusts and things to do. And again, if anyone on the call, you can book a wealth and legacy planning session with me. Usherina is going to put the link in the chat for you, so you'll have it. And if you register by the end of November, you'll get that $200 off any estate planning that you do or set up. So I would encourage you to sign up and get a meeting with me. There's no consultation fee for that. Let me see if and so Sharina put that link. If you know others who want to join too, you can send it to them. They can just put in Masterclass as the code, and then I'll know that they were there or someone they know is there, and get that discount before the end of the year. We do plan to have a class in December, and that one will more than likely talk about taxes and what to do for taxes for the end of the year, and go from there. So I hope this was helpful. Not a hard push to sell or anything at the end. I do want to let people know, again, I'm here to offer guidance and support for those who need it, and just have questions. We also do limited liability companies, set up businesses and nonprofit organizations and things like that. So if you have those questions as well, please send that information. So I'm going to look and see if I see any other questions in the chat. And I don't see any. You can put it in the chat if you have. I'll give another minute or so. Okay. I don't see any other questions. We will get the replay out to you in the next day or so, along with a survey. We just ask that you do the survey and give us some feedback on the class, the pace, other subjects that you may want to learn or hear about, and go from there. So I'm happy that everyone can make the replay and come if you missed it, and share it. And then also too, you would be able to share the replay with others. I think one thing we'll do is also have the replay available on YouTube, so people can go to YouTube and watch the videos, and then the other videos will start to come on YouTube as well. So without any further ado, I want to thank everyone for coming and enjoy your Tuesday evening. Thank you so much. Yep, stop sharing. And let me record.